香律师，我也要感谢陆梅吉教授，还有民间司法改革基金会请我来参加这个研讨会。有律师告诉你，我1986年到87年大学的时候到台湾来，特别学习中文，但是我好久，从那时候一直到现在没有很多的机会讲，所以我的中文没有以前那么流利，我要用英文讲。但是86到87年在台湾是非常有意思的时间。我88年也回来做点研究，你们好像都很年轻，所以你们可能不记得。但是台湾的86、87年，社会变革非常非常大。比方说，你们都知道民进党，87年是民进党第一次在台北示威，我出席了，那时候民进党示威，所以我现在台湾的社会情况完全不一样，所以我非常高兴有这个机会跟你们讲，这个题目，特别是美国政治开始的规范与实务。所以很抱歉，我现在要用英文讲。Okay. So, as you know, there is no criminal justice system that doesn't have some flaws. In theory, we want the government to be able to maintain social order, investigate crimes, and hold guilty parties accountable for their conduct. But at the same time, we want to make sure the government does not use its power against innocent people or misuse its power against those who may have done something wrong, but perhaps not exactly what the government has accused them of. I believe it is impossible to design a system that does this perfectly. But that doesn't mean we shouldn't try. The subject of evidence disclosure is absolutely central to the fair administration of justice. Without some understanding at the beginning of a criminal case why the prosecution thinks the accused is guilty, the defendant has no ability, no meaningful ability to investigate the facts, prepare the defense, or decide whether to plead guilty or proceed to trial. Now, you've probably heard in the United States, the fundamental principle of fairness to the accused comes from the Due Process Clause of the Constitution. The Due Process Clause itself is very, very simple. All it says is that no person shall be deprived of life, liberty, or property without due process of law. This applies to prosecutions by the federal government and by the individual states. But there's a big question about how this applies in practice. And the reality is the Constitution does not explain exactly what due process of law is. So it's the responsibility of the courts to really interpret this, and of the legislature to enact appropriate laws consistent with the Due Process Clause. I'm going to start from the beginning to explain how a federal case is initiated so we can understand the context of, in which evidence disclosure takes place. A federal case in the United States can start in one of two different ways. First, the prosecution can go to a grand jury, present evidence, and if the grand jury finds that there is probable cause to believe the defendant committed a crime, then the grand jury will return an indictment. Now, what's in the indictment? The indictment is a very plain statement of just the essential facts constituting the offense. It does not need to include detailed facts or list the evidence. It just gives the defendant notice of what the defendant is charged with and enough information to have some idea of what the case is based on. If a grand jury returns an indictment, then the defendant will either be arrested or may be permitted to voluntarily surrender to the court. But that's all the information a defendant has if the case begins by an indictment. It's very, very little information. The second way a federal case can be initiated is by criminal complaint. In this situation, the defendant gets a little more information, but there hasn't been a finding by a grand jury or the court of probable cause. With a criminal complaint, the prosecution just submits the complaint to the court. And again, it contains the essential facts constituting the offense, but it has to be supported by a sworn affidavit explaining the facts that support probable cause. Because the case hasn't gone to a grand jury yet, the grand jury and neither the grand jury nor the court has made a finding that there's probable cause to believe the defendant committed the offense. So this is just a sworn affidavit by the prosecutor or maybe one of the investigating agents. And if the court believes that there's enough information in there to establish probable cause that an offense was committed and the defendant committed the offense, then the court will issue an arrest warrant and the defendant will be arrested. A defendant who comes to court on a criminal complaint has a right to a hearing, probable cause hearing. But in practice, the defendant doesn't always get that hearing because if the prosecution goes to the grand jury before the date of the hearing, and gets an indictment, then there's been a finding of probable cause and the defendant loses the right to the probable cause hearing. So I practice in New York. I previously practiced in Texas. In Texas, the federal courts would always do the probable cause hearing right away. So we would get that hearing, the government would have to put on witnesses, and we could learn a lot about the case from that hearing. In New York, the prosecutors will never let that happen. They will always go to the grand jury before you can have that probable cause hearing. And that has the effect of limiting the amount of information the defendant has at the beginning of the case. Okay, let's talk for a minute about the grand jury. The defendant is not entitled to see the evidence presented to the grand jury. The grand jury proceedings are secret. In fact, it's a crime for anybody except a grand jury witness to say anything about what happened in the grand jury. There's no judge. There's just the prosecutor, the witnesses called by the prosecution, the grand jurors, and a court reporter. The grand jury witnesses in federal cases aren't even entitled to have their lawyer present in the grand jury. So it's a completely unsupervised proceeding. There is a record of it, but it's very rare that a defendant or a defense lawyer ever gets to see what that record looks like. The court may authorize disclosure of certain grand jury testimony, only if the defense can show that there may be a basis for dismissing the indictment based on things that happened in the grand jury, such as the knowing presentation of false testimony. But in reality, this rarely happens. And you can imagine why, because it is very difficult for the defense to make a showing of an impropriety in the grand jury proceedings if you don't know what happened in those proceedings. So we very rarely see what happens in the grand jury. Okay, so now we've got an indictment. We don't know what evidence was presented to establish the facts underlying that indictment. But this is where the case is now in court. The defendant makes an initial appearance, and the prosecutor has to begin to provide discovery to the defense. The prosecutor does not provide discovery to the court. The court oversees this process very generally, and at the initial appearance before the judge in the case, there will be some discussion about how much evidence is there. Is it going to take a long time to produce? What's involved? Is it electronic discovery? Is it just some reports? You know, and the prosecution will make some representations to the judge about how extensive the discovery is, and the judge will oversee the schedule for producing it. But as a practical matter, it's very informal. The rules concerning discovery do not actually set out a time frame, a specific time limit for discovery. A defendant can request what's called a speedy trial. Okay, a defendant has a right in federal court to have the case go to trial within 70 days of the date of indictment. So, in theory, the government should be ready to do that and should be able to produce all the evidence and discovery and let the defense prepare for a trial within that short period of time. But if a case is considered to be complex, and more this is happening, especially with complex financial crimes and cases with a lot of evidence or very many defendants. I mean, sometimes in federal court in the United States, I've seen cases, you know, with up to 100 defendants in one case. So sometimes just the case can be deemed complex, and discovery takes a very long time, and the judge will waive, or the judge will exclude time from the speedy trial requirement, so the defendant really doesn't have a right to get that trial within 70 days. But this is the point at which the prosecution does have an obligation to let the defendant know what the evidence in the case looks like. Now, a good defense lawyer will send a letter to the prosecution. It will be a long discovery letter, and it will ask for everything the prosecutor is required to produce under the discovery law and rules. Not every lawyer sends this letter. Every lawyer should send this letter because discovery is not automatic. You'll see when we talk about the rules, the defense really is required to request disclosure of this material. But discovery is an ongoing obligation of the prosecution. So the prosecutor should continue to provide additional discovery as it becomes available. We don't have, you know, specific periods of discovery or particular phases for discovery. It's just an ongoing obligation. The prosecution has to produce it, and this obligation goes on all the way through trial. And what'll happen, if a defense lawyer is really doing his or her job, that lawyer will send the initial discovery letter, get the first batch of discovery, look through it very carefully, and think about, okay, what does this tell me about what else might be out there that I didn't get, that I should get? Okay, and a good defense lawyer will continue to provide request after request if it looks like there's information out there that the government possesses or should possess that hasn't been produced. So there's a lot of responsibility on the defense lawyer to be aggressive in pursuing this. Okay, so what are the actual sources of the prosecutor's obligation to disclose evidence? There are several of them, and we'll go through each of these individually. First, Rule 16 of the Federal Rules of Criminal Procedure. The Federal Rules of Criminal Procedure function as law. Okay, these are binding rules. The prosecution must follow them. Rule 16 is the basic rule about evidence disclosure. Second, as I mentioned, the Due Process Clause of the U.S. Constitution. And then next, these are Supreme Court cases, U.S. Supreme Court cases, that have interpreted the Due Process Clause and have added to the prosecutor's obligations under the Due Process Clause. The most important one is Brady versus Maryland, a 1963 case. Giglio versus United States. Nobody in the United States knows how to pronounce that case name either, so don't worry. But I do know because I have asked the lawyer, one of the lawyers who worked on that case, how you pronounce it. That was a 1972 case. We'll talk about that in detail. Next is the Jenks Act. This is an act of Congress. Okay, so this is an actual law that was enacted by Congress that governs the disclosure of witness statements. And then Rule 26.2 of the Federal Rules of Criminal Procedure, that rule basically took the Jenks Act and made it into a rule and modified it a little bit. Okay, so let's go through these one by one. Rule 16. I know there's a lot of information on these slides. Maybe later I'll translate them all into Chinese and give them to you. Okay, Rule 16. Rule 16 lays out the obligations of both parties, the prosecution and the defense, because the defense also has some reciprocal discovery obligations. So here's what Rule 16 says. I'm not giving you every single detail of Rule 16, but these are the basic categories of information that the prosecution has an obligation to disclose. And you'll see, as I mentioned, this is upon request of the defendant. Okay, the government must disclose and make available for inspection any relevant oral statement by the defendant made to the government if the government intends to use it at trial. So if there was a confession, if there was a denial, if at some point the government interviewed the defendant, this could be an interview with the police, somebody from the FBI, doesn't matter. A statement by the defendant related to the case has to be produced if the government intends to use it at trial. Second, any relevant written or recorded statement of the defendant. So if the defendant wrote something down, if the defendant gave an interview and it was recorded, if somebody else wrote something down about the statement of the defendant, that needs to be produced. Any relevant recorded testimony by the defendant to a grand jury. A defendant in the United States has the right to testify in the grand jury. Well, I take that back. In federal cases, sometimes the defendant will testify before a grand jury if the defendant knows and has the opportunity to testify before the grand jury. If so, that defendant's testimony, but not the testimony of the other witnesses, needs to be produced to the defense. The defendant's prior criminal record. Okay, the government will have run a search for all prior arrests and prosecutions and convictions of the defendant, so they need to disclose that to the defense. The next category is this is sort of the big category. All documents and objects within the government's control that are material to the defense, that the government intends to use at trial, or that was obtained from the defendant. So, right now, for instance, in the United States, we have this big case where the president's lawyer's office was searched, and they took all kinds of materials from that office. Everything they took from that office, they have to give to that lawyer's lawyer so that he can review it. If I have a client and his cell phone is seized, eventually I'm entitled to get that phone back and to see any evidence that was on it. This includes things like photographs of a crime scene or of a victim's injuries. It'll include if there was a crime scene it's important for you to visit it. The government will have to make that available for inspection. If it's a financial case, this will include all the bank records. Anything that the government intends to use in its case at trial, or that came from the defendant, or that is material to the defense. And that's an interesting category, right? Because who decides what's material to the defense? Well, the prosecution's deciding what's material to the defense. But it has an obligation under this rule to disclose it. Next is results or reports of any physical or mental examination and of any scientific test, if it's material to preparing the defense or the government intends to use it at trial. So this would be, if the government tested drugs that were seized in a case, or if the government did testing on the bullet that was, or the bullet that was fired in a case, or it could be any kind of test or examination if the government's going to use those results at trial, or again, if it's material to preparing the defense, the government has to turn that over. And then last is if the government intends to use an expert at trial, the government will have to produce a summary of that expert's testimony. So they don't have to produce they don't have to give you verbatim what the expert's going to say at trial, but they need to give you background information on the expert, that person's qualifications, and give you generally a summary of what that expert is expected to testify at trial. What does the government not have to produce? If they have their own notes to each other about the case, those communications or internal memoranda, those things don't have to be produced. So if a prosecutor has a case memo that is delivered to a more senior person in the office explaining why we think we should be able to go to the grand jury, that memorandum doesn't have to be produced. Although, if it turns out later that the memo contained information suggesting that the defendant might be innocent, then that might create a problem if it's not disclosed. But in general, the internal documents, case documents, that aren't substantive don't have to be produced by the government. And I should add that, you know, this rule really pertains to materials that are in the government's control or possession. It should include information that's in the possession of any member of the prosecution team. And that prosecution team can include, it might be the local police, it might be the FBI, it might be another government agency. In securities fraud cases, usually the U.S. Securities and Exchange Commission, the SEC, might be doing its own investigation along with the prosecutor's office. Sometimes that relationship is close enough that they're considered to be part of the same prosecution team, and information that the SEC has should be produced in the criminal case. It's very fact specific, but this is one area that where there's often an issue. You know, what information is in the government's possession or control? You might have fights about, you know, things that you learn were in the possession of another law enforcement authority that you think the prosecution should have turned over, and they say, oh, we didn't know about it. You know, sometimes they'll send something later and say, oh, yes, somebody at the FBI just found this in a file. And, you know, really, the courts, for the most part, are not very sympathetic to that argument. They generally think, you know, each arm of the government should know what the rest of the government is doing. But, you know, as a practical matter, sometimes the government just doesn't produce things that they don't have immediate custody of, even though they should. Okay, so what are the defense obligations? The defense does have reciprocal discovery obligations under Rule 16. The defense has to disclose and provide for inspection of documents and objects that it intends to use in its case at trial. So this is, if the defense plans to go to trial and plans to actually introduce evidence, not in cross-examining the government's witnesses, but introduce in its own case any evidence, those need to be produced in advance of trial for the government. Also, the results of, or reports of physical or mental examinations and of any scientific test, if the defense intends to introduce it at trial, or call the witness who prepared it. And also a summary of any expert testimony the defense intends to use at trial. The defense is not required to disclose other documents made by the defense team during the case. So if I'm taking notes during a meeting with my client, or I'm doing legal research and I'm taking notes, or I'm coming up with my theory of defense, none of that has to be produced. Statements by my client to me don't have to be produced. And statements of potential witnesses to the defendant or the defense team don't have to be produced. But this is an area where lawyers need to be a little bit careful. Because if I have an investigator go out and interview a witness, and that investigator makes notes, if that witness later testifies at trial, we will have to produce those notes at some point. And so usually defense lawyers, often defense lawyers will not actually take notes of, detailed notes of witness interviews. But that's a decision that individual lawyers will make. And let me just say, today I'm going to talk about these rules and especially focus on the issue of disclosure of information that may be favorable to the defense. And tomorrow we'll talk in greater detail about how we deal with prior statements of witnesses, because that's a very, very important issue, and there's a lot to say on that subject. As far as the defense obligations go, as a practical matter, these obligations really only arise if the defendant, or if the defendant plans to go to trial, okay? And that's a decision the defendant doesn't have to make at the very beginning of a case. It's a decision the defendant, might make very close to the time of trial. And so, there's no time frame for the disclosure of this information. And usually, if the defense is going to actually go to trial and put on a case, this material will be disclosed very shortly before trial. The one exception is expert reports or scientific tests. And that's because when there's an expert witness involved, there's a lot more potential preparation that needs to be done. If one side is going to be using an expert witness, the other side may want to bring in its own expert witness. And so it's important to get the summary of the expert's testimony sufficiently in advance of trial so the other side can prepare for cross-examination and also to possibly bring in its own expert. So this is one area where the court the judge will ask the parties in advance if they intend to use experts and make sure that those reports are disclosed sufficiently in advance of trial. There's enough time for everybody to prepare. Okay, so Rule 16 seems pretty clear. It seems to be pretty comprehensive, but there's still a lot of room for disagreement about what needs to be disclosed. And when that happens, either party can make a motion to the court for an order compelling the other party to produce what it thinks hasn't been produced, okay? This is called a motion to compel, and what you'll do is you'll make a motion and explain to the court what you requested. This is why you want to have that discovery letter. So you can say, I asked for all this stuff. I didn't, and I think that, items A, B, C, D exist for these reasons. They haven't been produced, and I think the government has an obligation to produce them, and I'm asking you, Judge, to order the government or the prosecutor to produce these. If the prosecution hasn't produced something and you have to go to the judge to try to get it, they're going to generally fight very hard and argue that they don't have an obligation to produce it. But ultimately that's going to go to the judge, and the judge will make a decision, and the parties will have to live with it. I'm just going to give you one example from one of my cases about a situation just to illustrate how much room there is for disagreement about Rule 16 discovery. So in federal drug cases, the government typically will seize an actual substance, an actual thing that they say is a controlled substance. They need to test that substance because one of the things they're going to have to prove is that there was an actual controlled substance involved in the offense. And so they'll send it to a lab. The lab will conduct its tests. And what they produce to the defense usually is one sheet of paper, and it says, here's the item that was tested, and here's the conclusion, and it contains this quantity of X drug. Okay, you get one sheet of paper. How many of you have ever done an examination of a controlled substance? How many of you have ever looked at the lab reports, the lab analysis that goes into this? Anybody? Okay, let me tell you, this is not a one sheet of paper kind of test. In my case, there was very serious doubt about whether the substance that had been seized was an actual drug. Okay, we learned at the beginning of the case, when they did what's called a field test, that is, they do a quick test out in the field at the time of the arrest, it actually came up negative. So there was a real question about this. And when I got the lab report, all it showed was microscopic traces of any drug, okay? So, I talked to some other defense lawyers about this. I thought this was very suspicious. And I demanded to see the underlying lab analysis so that I could cross-examine the lab analyst at trial and challenge that conclusion. Because if there wasn't any actual drug, then there was no case. The government could not prove that my client had been in possession of this, of any drug. So the government, of course, had never seen such a request. They're used to being unchallenged. So, the prosecution, first of all, didn't even know what I was asking for because they'd never produced such a thing. The reality is, when a substance is tested in a lab, there are pages and pages and pages and pages of individual test results. I mean, hundreds of pages, okay? And this is very complex scientific testing that's done. It is not a simple yes or no answer. There's actually a lot of interpretation involved in this. I see some people nodding. Are there some scientists in the room? Yes? No? This is not simple, okay? And this goes to what we heard earlier about, sometimes lawyers just accept what's presented to them, right? You accept the list of things and you think that's all there is. Well, no. Usually there's a lot more behind whatever is on that one list. So, of course, the government first didn't know what I was asking for. And then I explained. And then they said, oh my God, we can't produce all that. And they were very worried because if they had to produce that to me, then every other drug case that they prosecuted, they were going to have to produce the underlying lab analysis. So they fought me. The court initially agreed with the prosecutor, but I eventually persuaded the government to produce this, and I got the documents, and that was turned out to be a very, very important part of our trial. And I think it's possible in my case that that I ended up getting them because the government realized that they might have more problems down the road if they didn't produce it. If I had gone to trial and my client had been convicted and we'd already had this big fight about production of these items, I would then have a very good argument on appeal that the trial wasn't fair. So ultimately I got the documents. But I give this example because, you can try very hard to create clear rules, but the rules aren't going to they can't cover every single specific situation. You want them to be as clear as possible, but you also want to have determined counsel on both sides. And you also need to have fair judges. Okay, so whoever's overseeing this process of evidence disclosure plays an extremely important role. And And it's all part of the whole system. In order for the system to work, all these components have to work together. Okay. Now let's turn to case law. Case law is what we call the court decisions interpreting the law. It could be a law enacted by Congress. It could be the United States Constitution. In criminal cases, it's very often the United States Constitution. So Brady versus Maryland was a 1963 case. How many of you have heard of Brady? I know at least Yo Xiang has, because I've read his article discussing this and some of the other cases. But Brady versus Maryland is probably the most important case regarding evidence disclosure that we have in the United States. And this is one of several cases the United States Supreme Court has decided establishing the prosecution's evidence disclosure obligations. All of these decisions are rooted in the Due Process Clause of the U.S. Constitution. And again, this is all about ensuring that a defendant has a fair trial. Okay, so in Brady, the Supreme Court held that due process is violated when, after a request by the defense, the prosecution suppresses evidence, that is, doesn't disclose it, that is favorable to the accused, and that is material to either guilt or punishment. Okay? So again, the court held that it is a violation of the Due Process Clause for the prosecution to suppress evidence that is favorable to the accused when that evidence is material to either guilt or punishment. It doesn't matter whether it was a decision made intentionally or unintentionally, okay? Even if it was unintentional, it can still violate due process. And if there's a violation of due process like this, the court will reverse the conviction and send the case back for a new trial. And I included here a quote from the U.S. Supreme Court because I think this is important, and I think this really applies to any society that cares about the rights of those accused by the government. And the court said, "Society wins not only when the guilty are convicted, but when criminal trials are fair. Our system of the administration of justice suffers when any accused is treated unfairly." Okay, that was 1963. In 1972, the Supreme Court decided Giglio versus the United States. And this case concerns disclosure of impeachment evidence, okay? So in Giglio, the Supreme Court clarified that the prosecution's obligation to disclose evidence favorable to the accused also includes evidence that can be used to impeach the credibility of a key prosecution witness. In Giglio, it turned out there was only one witness in the case who connected the defendant to the crime. And after the defendant was convicted at trial, the defense learned for the first time that the prosecutor who had presented the case to the grand jury had promised that witness that he would not be prosecuted if he testified before the grand jury and at trial. Okay? So the prosecutor goes to the, he's interviewing this witness before indictment, and he tells this witness, who's the only person connecting the defendant to the crime, you will not be prosecuted if you testify before the grand jury and at trial. Now that's information that is very significant to a defendant who wants to maybe cross-examine that witness during trial. But the prosecutor who made that promise did not tell the prosecutor who later tried the case, okay, who later presented the case to the jury. So the prosecutor who took the case to trial did not know about that promise, but the Supreme Court said that doesn't matter, okay? That promise was made by the government, it was made by a member of the prosecution team, and so the government as a whole had responsibility for it. And the court also concluded that the credibility of the witness was so important to the case that a new trial was required, okay? Now, this gets us to the issue of materiality. I think materiality, is this what you call 重要性? It's, you know, how important is this information to the case? In Giglio, the court was careful to state that a new trial is not required where the prosecution failed to disclose evidence possibly useful to the defense, but not likely to have changed the verdict. So if the court had concluded that the information might be helpful to the defense in some way, but wasn't likely to change the outcome of the case, and we wouldn't have had a need for a new trial, okay? And the same thing happened in Brady. In Brady, the court stated that due process is violated only when the favorable evidence that was suppressed is material to guilt or punishment. So that raises a very big question about what evidence is material. Who gets to decide what's material? And when does that decision get made? Does it get made only after trial when you know what the outcome is and you can assess it in light of all the evidence? Or does it get made beforehand? So in general, evidence is considered material if there is a reasonable likelihood that it could have affected the judgment of the jury, okay? So if there's a reasonable chance that the evidence would have caused the jury to come to a different conclusion, then the evidence is considered material. And that's the standard that the courts apply in retrospect, that is looking back at the case after there's been a conviction and after it's gone up on appeal. So the court is making that decision after the fact. And most of the time, in the vast majority of cases, courts conclude that the undisclosed evidence was not material because there was sufficient other evidence of guilt. So again, this decision is being made by the courts after all the evidence has been presented, the jury has convicted, and the defendant is now saying, but wait, if I had known this, if I had had this piece of evidence, you know, I could have done something with that, and there could have been a different outcome. But the courts are very reluctant to accept that argument. So I think that there are a number of problems with the way the United States currently approaches disclosure of evidence under these cases, Brady and Giglio. So the courts decide after trial and conviction whether the undisclosed evidence was favorable and material. But it's the prosecutors who are making that decision in the first place, okay? This standard that the courts have created is what has now become the standard that the prosecutors use when they're deciding what to disclose in the first instance. And this is worth thinking about, because the prosecutors have already decided to bring an indictment. They believe that they'll be able to convince a jury beyond a reasonable doubt that the defendant is guilty. And those are the same people who are now deciding whether a particular piece of evidence is likely to raise a reasonable doubt in the minds of a jury. Okay, I've handled hundreds of federal criminal cases. Only one time did I receive a letter from the government saying, I am providing Brady material to you. One time, okay? And I don't think that every other prosecutor was deliberately withholding favorable evidence. I think even if prosecutors are very well intentioned and they're trying to do the right thing, they think they're following all the rules, they are viewing the case from the perspective of the prosecution. From that perspective, it is easy to conclude that the weight of the evidence is so overwhelming that the potentially favorable piece of evidence wouldn't make a difference. And so when they come to that conclusion, the prosecutor says, well, I have this piece of evidence that might be favorable, but I have all this other evidence of guilt, and if I presented all of this to the jury, this isn't going to make a difference, and so it's not material, I don't have to disclose it, I'm going to just leave it in my file and not tell the defense. So, in my opinion, the first key problem with letting the prosecutors decide what evidence has to be disclosed pursuant to these cases, Brady and Giglio, is that the prosecutors are institutionally incapable of viewing the case from the defense perspective or even from a neutral perspective. And therefore, they may not recognize that certain evidence is both favorable and material to the defense. The prosecutors don't know what the defense is. They have one singular perspective on the case based on their investigation. In most cases, they haven't spoken to the defendant. They don't know the defendant's story. They don't know and also they've never been defense lawyers, so they don't know what a defense lawyer might do with that piece of evidence. It's never occurred to them. Think about my drug case. They didn't even know what material had been produced by their own lab analyst. So they had no idea that information could be material to the defense. So this is a similar problem to what we heard happens in Japan. When you're relying heavily on the discretion of the prosecutor, there is great potential for favorable and material evidence to not be produced. And it's not always because the prosecutors are deliberately trying to withhold the information. Sometimes they just don't know what would be material to the defense. Okay, second, prosecutors know that if they decide not to disclose evidence, that decision will only be questioned if that evidence is subsequently discovered. Okay? Now, if a defendant is not aware of potentially favorable evidence, that defendant is more likely to underestimate his chances of success at trial. And that defendant is therefore more likely to plead guilty, and therefore more likely to scrutinize the government's evidence less carefully. So, knowing all that, the prosecution may decide that not disclosing is a reasonable chance to take. It's a reasonable decision, because it's more likely than not the defendant won't discover this evidence. Also, even if it does get discovered later, the prosecutors know that the defendant, who has now been convicted, will have a very difficult time convincing the court that either, if he'd known about the evidence, he would have gone to, if it was a guilty plea, the defendant will have to convince the court that he would have gone to trial if he had seen that evidence. And if he went to trial, he's going to have to convince the court that the evidence would have resulted in a different outcome, or would have been likely to result in a different outcome. And the prosecutor knows the chances of the defendant being able to prove either of those, or convince a court of either of those, is unlikely. And the prosecutors also know that if they do decide to disclose it, the defendant might decide he has a good chance of succeeding at trial. So he might go to trial, and now he'll have the additional evidence that might help him challenge the government at trial. And so disclosure might mean that the prosecutor will not get a conviction in that case. So this is the second key problem with letting prosecutors decide what evidence is favorable and material to the defense, and that is, there are many incentives in the system that favor suppression of the evidence over disclosure of the evidence. You know, in general, in the United States, over, I'd say 95% of cases result in guilty pleas. And that's the preference of the prosecutors and the courts in general, because it's much more efficient. If more defendants went to trial, it would be a lot of extra work for the prosecutors. It would be a lot of extra work for the courts. It would be very unmanageable. It would result in the prosecutors probably bringing substantially fewer cases. And so, you know, a lot of the rules and decisions are made with this in mind. And there's a real preference, I think, for encouraging guilty pleas. And so the rules of evidence disclosure tend to be fairly conservative because it's one way of discouraging defendants from going to trial and encouraging defendants to plead guilty. The third key problem that I see with the current US approach to disclosure of evidence favorable to the defendant is that there are rarely consequences for the prosecutors who fail to disclose favorable and material evidence. Experience has shown that even in cases when the courts conclude that the failure to disclose violated due process, it's very rare that the prosecutors suffer any negative professional or personal consequences for suppressing the material. So the third problem is that there's great reluctance to discipline or to punish prosecutors who violate the due process rights of criminal defendants. Okay. Okay, so what are the alternatives? I want to propose a few different possible approaches for your consideration, since Taiwan is in this very interesting position of trying to decide what kind of system do we want to put in place. And I think it's very important to get it as close to correct as you can at the beginning, because it's only going to get harder to change it later on. Number one, I think that in the United States we should consider changing the standard for disclosure of evidence. The current standard comes from these court decisions reviewing undisclosed evidence after trial. And at that point, the courts understandably do not want to undo convictions unless it looks like the trial would have been different with the evidence. But that may be an appropriate standard for the courts looking at a case on appeal. That doesn't mean it's the right standard for prosecutors looking at the case at the very beginning. And so there's no reason that we can't adopt an independent rule separate from those case decisions governing disclosure of relevant evidence. One simple approach would be to require the government to disclose all evidence that may be material to the defense, okay, as opposed to material that is relevant to the defense, or material to the defense, or that the government has determined is material to the defense. If you let the government determine that in the first place, they have a lot of incentives to decide that information, favorable information, is not material. If you require them to, if the rule is they have to disclose any evidence that may be material, you are encouraging more production rather than less production, and in my view, leading to more fair outcomes. Another possibility, which I think personally is less practical, is you can have another entity that's neutral oversee evidence disclosure. So, right now, the way it works in the United States, I think it's nearly impossible for the prosecutors to decide fairly what evidence needs to be disclosed consistent with due process. If we were to keep the standard the way it is, it might be better to have a judge who's not the judge overseeing the case, but a separate judge, oversee the process of evidence disclosure and make determinations about whether evidence is favorable and material to the defense. Right now in the United States, in criminal cases, the judges never see all of the evidence in the possession of the prosecution. At most, what the judge will see is all of the evidence that is produced at trial, or evidence that might be presented to the court in pretrial motions, but there's no systematic procedure by which all of the evidence gets presented to a judge, who then gets to decide what needs to be presented to the defense. I think there would be great reluctance in the United States to adopt that kind of an approach because it would use so many judicial resources. So I think it would be hard to implement, but it is one thing to think about, particularly in Taiwan, where you already have something more along those lines than we do. A third possibility is to make sure there are meaningful disciplinary procedures for violations. There has to be some consequence for prosecutors who fail to disclose evidence favorable and material to the defense. When there's no possibility of disciplinary action for due process violations, prosecutors are less likely to disclose and more likely to suppress when there's a difficult decision to make. And I think that as a matter of policy, we should be encouraging prosecutors to disclose more and suppress less. And I think one way to do that is if the system is less tolerant of these decisions not to disclose. You know, right now, if there's, like I said, courts really don't have the ability to take action against prosecutors in cases where they found a Brady violation after trial. In the middle of a trial, if the court orders the prosecutor to disclose certain evidence and the prosecutor doesn't do that, the court has the ability to hold the prosecutor in contempt and, you know, could maybe lock them up until they produce it. I don't know of any judge who's really done that. So it's really not up to the courts to discipline the prosecutors. A defense lawyer could make a complaint to the state bar, to, you know, whoever has actually licensed that lawyer, and complain that that lawyer has violated the rules of professional conduct. But because so many of these decisions are discretionary, it's very difficult for those types of proceedings to result in disciplinary action. Another thing defense lawyers can do is file a complaint with the Department of Justice itself. It has what's called an Office of Professional Responsibility. We call it OPR. So this is part of the Department of Justice itself, and this is the internal group of people that decide whether or not the prosecutors have behaved according to the rules of professional responsibility. Those cases, first of all, defense lawyers are reluctant to file complaints because we deal with these prosecutors and their offices over and over again. And so there's a real fear that filing a complaint could be damaging to our future clients. And the last thing a defense lawyer wants to do is disadvantage a client based on the lawyer's conduct. So there's a fear of filing complaints with OPR. Even when they are filed, OPR takes years to investigate them. They rarely make a finding of misconduct, and it's even rarer that there's a real sanction or real punishment against a prosecutor. And another thought I had, it's not on this slide, but one other way to approach this would be to strengthen the rules regarding the gathering of evidence. So in the United States, there is something called the United States Attorney's Manual. The US attorneys have their own internal rules for how they gather evidence, all the places that they should look for evidence, the kinds of things they should investigate. The U.S. Attorney's Manual, however, is just their own internal policy. It's not a law. So they're not even required to follow their own guidelines. We don't, apart from their own internal guidelines, we don't really have standards that say what the government needs to go and look at. So for instance, the Department of Justice has said that prosecutors should investigate, any mental health or drug problems that a witness for the prosecution might have. But they're not required to do that. So, if they have a witness who has those problems, maybe they'll look into it, maybe not. And if they don't, then they don't have information, and that person does have a problem, then they don't have information that they have to disclose to the defense. So it's worth thinking about, to what extent should we require certain kinds of investigation and certain kinds of evidence gathering by the prosecution in the first place. Another possibility is, we don't record, we don't videotape interviews or interrogations of defendants. This is an issue that is discussed often in the United States. Some jurisdictions have decided to do it, but in most instances, interrogations of defendants are not videotaped or recorded. If they were, that would be something that would have to be turned over to the defense. And so, rules like that, where you're requiring the prosecution to, or the government to adopt certain procedures that will result in evidence that's material, is another way to, I think, strengthen the overall system for evidence disclosure. That's all I have for today. We still have some additional time. If anybody wants to ask me specific questions, I'm happy to take questions, or we can move into the next segment. Yes? Oh. Yeah.
I thought with the interrogation in America, it's like they are under the law to be recorded and videotaped. After the Simpson case, I thought they are being done in America.
No, the question is, I thought that all interrogations had to be videotaped in the United States, and no, they don't. Very often what will happen is the defendant will be taken into custody and put in a room, and the police or investigating agents will ask the defendant questions. Hopefully they will give that person Miranda warnings and let them know that they don't have to speak, but that if they do, anything they say can and will be used against them. Also let them know they're entitled to a lawyer. If the person decides to speak, usually somebody will take handwritten notes of that and then type up a report later. And then that report becomes the record of the defendant's statement. Sometimes they'll have a defendant, they'll do an interview, not recorded, not with anybody taking notes, and then later have the defendant write out his or her own statement of what happened and sign it, and then that becomes the statement of the record of that interview and the statement of the defendant. So there are many different ways this can be handled. There is not one consistent standard. And again, I mean, if there were, maybe it would help eliminate problems of false confessions, for instance. Although sometimes you have the problem, even when interrogations are recorded, there might be communications or interactions that took place before the camera was turned on, or maybe that took place after the camera was turned off. So, you know, there's always the possibility for people who aren't ethical to create problems. But I think we can try to design policies and procedures that maybe help ensure more fairness in the majority of cases.
May I ask a follow-up question?
Okay. It's like, I know there's like police brutality problem in America. Do police torture the accused into confession? And can that confession be used in court legally?
So it can happen. I don't think that is I can't give an opinion on whether that's a widespread problem. My sense is it's not a common occurrence, but it can and does happen. When that happens, usually the defendant will tell his or her lawyer about it, and the lawyer will try to demand as much information about the circumstances as possible and do an investigation, but it's very difficult to prove. If, though, there is sufficient evidence that there was coercion in an interrogation, a defendant can ask the court to suppress the use of that statement. And so what will usually happen is there will be an evidentiary hearing before trial. This would be a pre-trial hearing where the witnesses to the interrogation would have to testify, would be called to testify, and the court would make a determination about whether or not that confession was coerced. And if the court finds that it was, the court will suppress the confession. Any other questions before we run out of time? Okay. Tomorrow, I want to discuss the issue of prior statements of witnesses. As I mentioned earlier, that is a very, very large subject, and so I'd like to spend a considerable amount of time talking about that. So I don't want you to worry that I haven't addressed it today. We'll talk about it in detail tomorrow. Thank you.
谢谢宋律师非常精彩的演讲，带给我们很多很深入的说明，还有很丰富的收获。那如果说现场的朋友没有进一步的问题，想要在这个阶段就询问宋律师，那我们不妨把那个休息时间往前提前啊。现在的时间是2点55分啊，那我们就从2点55分开始休息啊，然后到3点10分，我们3点10分回到这个会场。那谢谢各位，谢谢。